Fast forward, you can come our channel, so AGH Politics Avenue. On your podcast, or the trending because making headlines. And a jammer not ADB Akroma, our any dim ne and Braximus, and AD Kenya. Best which must subscribe to the channel. It's a notification bell, so share now upper front so answer into me and B. I'm sure when you can say what me I am, sir, in Seminim. Now, Ayana or or comment constructively under the comment section. And the man. Yanko aye high wisdom. And chairman Wontumi and then lawyer. And the appear could be etimi ecopiemu ewo a year court. Unia the ecopiemu hono na chairman Wontumi Jubilate and all any assembly to Accra. Na a dear bay and a cofa jubilation we see to me a buyer at this point in time. Lawyer for the accused person, chairman Wontumi etimi approve into it, giving us in-depth analysis on exactly what transpired at the court proceedings today. Let's proceed.
Fair enough. But as it stands, it is quite unfair to drill down simply to fuel issues and matters related to commercial and technical losses.
Thank you so much, Mr. Lom Nuku, for your time here on The Pulse. Well, away from that, let's head to the courts now, because an Accra High Court has dismissed an application by lawyers for the Ashanti Regional Chairman of the New Patriotic Party, Bernard Busiako, popularly known as Chairman Wontumi, seeking additional disclosures from the prosecution. The defense had argued that the documents they requested were crucial to the management of the case. During today's hearing, both sides argued their position, with Deputy Attorney General Justice Ramsay urging the court to dismiss the application. After considering the submission, presiding judge Audrey Tay ruled against the defense, effectively striking out the request. Fatal Bayaga was in court. He filed the report.
Chairman Wontumi, the Ashanti Regional Chairman of the New Patriotic Party, is back in court today in relation to the Samaraboy concession case. In this case, Wontumi is facing charges for granting mining activities in his concession without the necessary ministerial approval. The last time the court sat on the issue, lawyers for Chairman Wontumi, led by Indepth told the court that the prosecution should disclose some further details or documents to help in this particular case. The court then adjourned the case to today, and in today's case, the presiding judge, after listening to the arguments by both Wontumi's lawyers and the prosecution led by the Deputy Attorney General Justice Ramsay, dismissed this particular application. Despite that the application was dismissed, Chairman Wontumi's lawyers say they are happy with the court's decision.
Though the court said that the documents we were looking for were irrelevant as per the Attorney General's submission, we are confident that same will not be tendered or relied on during the trial, and we achieved the purpose for which we filed the motion. So we are very happy this morning that there is no proof of conveyance. There is no proof of ownership of those equipments coming from Chairman Wontumi. So these were the positions that we sought in our application. Indirectly, we have gotten them. What it means is that the Attorney General cannot bring any surprise of a document purportedly authored by Chairman Wontumi to the said Henry Inkum. And that Attorney General can also not bring any document proving ownership of Chairman Wontumi in respect of those ammunitions that the police purportedly seized on site.
Well, let me bring in the lead counsel for Chairman Wontumi, Indepth. We appreciate your time here on The Pulse. I just wanted to get your initial reaction. We've just been hearing from you just outside the court saying you achieved your purpose. How exactly did that happen? You have to unmute for me to hear you clearly, sir. Mr. Indepth, you have to unmute for me to hear you clearly. Or just trying to reconnect our lines to speak to Indepth, his lawyer for Chairman Wontumi. He's just giving us updates as to what exactly transpired in court. They have been pushing prosecution to release certain documents to them, as they say that it will aid their defense for the case in court. Unfortunately, today, the High Court judge presiding over the case struck out the application. I'm just getting in touch with Anya Piakubi right now, who's on the line. I'm told I have clear connection to him now. You say that your mandate has been fulfilled. How exactly is that? Explain it to me, because the court has struck out your application.
Right. Our application was seeking further disclosures, and the documents we did were the conveyance between Chairman Wontumi and the witness statement who filed, the witness who filed his witness statement. Indeed, perusing the witness statement, we realized that the witness had alleged that Chairman Wontumi assigned his interest in the land to him to do the mining, and that the Chairman Wontumi's offense is that he did not seek the concurrence or the permission of the minister to make that grant. So we had come to court seeking a copy of the document purportedly authored by Dr. Chairman Wontumi, granting access or transferring his title to the said witness. And in response to our application, the Attorney General made the court aware that there is no such conveyance or there is no such document transferring title to the said witness, and therefore that document doesn't exist. Indeed, our application had the objective of seeking the existence or otherwise of the said document purportedly transferring interest in the concession to the witness. And for us, the purpose is achieved because Attorney General says that there is no such document in existence. And that's all we sought to verify. Again, the witness had said that the police seized some ammunitions on site, and that these ammunitions are in the custody of the police. That is from the witness statement. And we said that, and they are saying that the ammunitions were given to them by Chairman Wontumi. So I had gone to court seeking a proof of ownership of the seized equipment. And the Attorney General is saying that they don't have any evidence of proof that the equipments are owned by Chairman Wontumi. For us, that is the essence of what we sought from the court. And now that we know that there is no such evidence of...
Oh dear, we seem to have...
of the witness saying that Chairman Wontumi gave it to them, saying that Chairman Wontumi gave it to them, cannot be sustained. And again, the fact of the matter is that the Attorney General says they are not privy to any document seeking to transfer interest to their witness. So let them come to prove how the Chairman Wontumi transferred his interest to the witness. And it is a matter for them to prove. We are satisfied that there is no such document transferring interest from Chairman Wontumi or Akuffo to the said witness. So let us move on. Now that we know that Chairman Wontumi has not transferred any such interest, let them come and prove how Chairman Wontumi transferred his interest to such a witness. So we are satisfied with the ruling. And indeed, if the Attorney General had come to court saying that there is no such document and that we don't have any proof of ownership of the ammunitions as laying with Chairman Wontumi, we ourselves would have withdrawn the matter. You understand? We would have withdrawn the motion because that is what we sought to do, to verify whether or not they are in possession of a document purporting to transfer the title of the concession to another person. They have answered it. The court also acknowledges the fact that no such document exists. So we are fine, we move on.
But do I get a sense you're well aware that the Deputy Attorney General in government, to be precise, did not even have this document in their possession in the first place?
Well, whether or not they had the document in possession, that was the government of the child. He has transferred interest to the witness without due authority. So if they say that they don't have any document confirming such transfer, we are fine.
And what does this mean for your case moving forward as we wrap up briefly?
No, we will come back and organize a case management conference. So we are ready for it. We were only concerned with mobilizing all the necessary documents before we start our defense. So now that that document doesn't exist, we are ready for the case management conference.
Thank you so much, Andy Apiakubi is counsel for Chairman Wontumi. You're still watching The Pulse. We'll be back after this quick turn. Please stay with us.
On December 2nd, 2025, this we find unacceptable. Following our meeting this afternoon, the TUC has resolved as follows. 1, in the spirit of fairness and mutual respect for our social partnership, we demand that government suspends the announced tariff increases. B, government and PRC should, as a matter of priority, immediately engage as agreed to exhaust the consultative process. Leadership of TUC wishes to assure Ghanaian workers that it will resist any tariff increases that would erode the mega 9% government wage adjustment unless government comes back to the negotiation table to top up the 2026 wage adjustment. Why should for the new tariff increment come January 1, 2026, when the mega 9% pay adjustment will be paid at the end of January 2026? This obviously borders on insensitivity. Signed by the Secretary General. Thank you.
We gonna roll the union song.
Well, that news conference was held earlier today. Let's bring in now a Labour expert, Austin Gummy, as we just flesh out some of the key concerns that has been raised by TUC. We appreciate your time here on The Pulse. I just wanted to start with your thoughts. What's the feasibility, really, of the demands they're making, especially because we know that the 2026 budget has already been passed by Parliament?
Stands to establish, first of all, that TUC has been established to seek and protect the economic and social interests of working people in Ghana. And that is exactly what they are seeking to do. They are aware that it does not take one side to approve or disapprove. Otherwise, it will lead to chaotic kind of disorder. When it comes to the issue of adjusting pay and also tariff adjustments and so forth and so on, there are rules and there are procedures that they all follow, as I know it to be. And therefore, they will have to follow that procedure in protecting and seeking the economic and social interests of their people. There's nothing wrong with that, except, of course, it's organized labor, or TUC for that matter, and therefore, language sometimes may be a little inflammatory, but it's permissible because they are TUC, And so that should not be taken on board as something grievous. All government or the employer have to do is to engage them so that they can have a solution that will satisfy both sides.
TUC, during the news conference today, they stated clearly that they want government to come back to the negotiation table. But then we do not know if they have triggered the processes. Should government be finding out about this decision via a news conference? What's the standard procedure?
Well, to be honest with you, governments, as I know it to be, I have been in that office before. The government is supposed to be proactive when it comes to issues of labor. Labor is a national security issue. And therefore, I am pretty sure, knowing the caliber of the government in place, they will have to trigger their proactive approach in calling for a national tripartite committee meeting. Because these are macro issues, not necessarily the one that is negotiable in the common hands of both parties is how to adjust pay based upon the GDP of the country and related matters. Now, this is a macro issue, and workers in the utilities are members of TUC. Let me repeat that portion. Workers who work in the power sector, in the water sector, are members of TUC, and they have their general secretary that belongs, that is affiliated to the TUC, and so they are also not oblivious of the fact that these monies are there to, in one way or the other, ensure that we have a stable power for all other workers to be able to work in their various industries. So both parties have a case, and so I will not, if I were to be government, I will not shy away at all in getting the labor minister, of course, the power sector ministers, to get together to enable them to have a conversation about this issue. It's not something to go and argue for somebody to win or lose. It's something that is so sensitive and dear to the whole nation, not only people who are working in those sectors and the whole country. We need water, we need power, we need stability, and therefore all are important. So I will urge government and TUC to get to the table, leave out the insensitivity aspects of the whole thing, and talk it over. I think they can find a solution that satisfies all of them.
Talk it over, you say, but then the concern now really is that TUC has given government two options, really. Pull the brakes on the implementation of the tariff hikes, or you can go back to the negotiation table and work on our base pay increment. From where you sit, because you have sat in different labor AMPA's mediation meetings, what is the most viable option for government as we speak?
I think they have a very strong point. One, organized labor are not oblivious of the fact that we need a stable and continuing power and water, clean water, and also the working people of this country. Generally speaking, it is power that we rely on to do the work that we do. And so when they get to the table, they can talk it over. They are not asking government that tomorrow morning, if they don't withdraw the increment given by the PURC, the whole country will go in flames. That's not what they said. If I heard them well on your network, clearly what it is that they are asking government to come forward for a negotiation. Negotiation is in diverse ways. So when they get to the table, they can discuss, and TUC will either understand, amend their concern, and be part of the solution, or otherwise. I think that government has a strong point. I have not been consulted by anybody, but I'm talking to you from where I sit. I think that if I were to be in their shoes, both sides have a very strong point, and they should go and ventilate on the issues, as it were, and there'll be a remedy for it.
You made mention that ECG and Ghana Water Company workers are all members of TUC, and that's the challenge government has to deal with moving forward. Looking at the fact that TUC members are making this push at this point in time, the concern really is, do we even have the money to grant their requests if we're going to look at base pay renegotiation, knowing fully well that Parliament has already passed the 2026 budget?
Well, let me clarify that portion. I'm saying that the workers that work in the power sector and the water sector have their general secretary and the whole labor relations affiliated to the TUC, and therefore they have a point also because they are also going to get pay increase. And their pay increase is based upon the fact that they are working, they increase their tariff for other people such as us, you and I, to pay to enable them to be paid as well. It's not something that they can sell and make profit as such. And therefore, when they get to the table, indeed, I strongly believe that both parties have a very strong case. Government and PURC.
We and Semahuro Tim Coso, our channel, so Mamma so Jimre or the Senes Obadian, Eri Adumbi Adumini, Unions and Shem, not young small person, Age politics of